The High Court in Pretoria has ruled that former National Commissioner of Correctional Services, Fraser's decision to place former President Jacob Zuma on medical parole was unlawful. The court has ordered that the former president should return to jail. Zuma was meant to serve a 15-month prison sentence, but his imprisonment at Escort Correctional Services was cut short when Fraser released the former president on medical parole. It later emerged that Fraser's decision went against the advice of the Medical Parole Board. This decision then sparked the court application by the Democratic Alliance and the Helen Suzman Foundation, amongst others. At the same time, the court also states that the time Zuma was out of jail on medical parole should not be counted for the fulfillment of his 15-month sentence. Zuma was convicted of violating a constitutional court order that he appear before the State Capture Commission of Inquiry. For more, I'm joined by Benedict Phiri, who's the Managing Director at IUS Prudential Specialist Counsel. Good afternoon, Benedict. Let's talk about some of the legal issues that come to the fore, especially when it deals with this particular case.
Yes, and I think the court judgment really clarifying those issues in detail. The first is, there's a constitutional court order that the former Correctional Services, Mr. Fraser, is actually seeking to work against and negate its effectiveness. So that was a legal issue that the court was taking very strongly into consideration in making this determination that the former president be sent to jail. Secondly, was the actual operation of the Correctional Services Act when it comes to issues of medical parole and where the decision around medical parole lies ultimately. And secondly, clarifying that the only people that could be allowed for medical parole are people that are terminally ill and also or facing a life-threatening incapacitation situation. So I think the court very clear that those were the three issues that had to be articulated and clarified and dealt with in its judgment, and I think dealing with it quite extensively and well.
Right. On that particular note, I mean, when I look at the preamble to Judge Elias Mutojane, I mean, he talks about the aspects in which he rejected, the arguments that he rejected. And one of them was that Zuma had argued that the challenge to his release on medical parole was moot because he was now eligible for ordinary parole. And he contended as well that it was virtually guaranteed that he would be granted such parole. Judge Mutojane rejecting that argument because the case that was brought forward here was that the case was therefore academic, and he also rejected the argument made by Zuma and Fraser that the Helen Suzman Foundation, AfriForum, and the DA do not have the legal standing to challenge Zuma's release on medical parole. What did you make of some of the, I suppose, rejections that Judge Mutojane made in this particular ruling?
Yeah, I think if we start with the question of mootness, I think Judge Mutojane being very clear that the issue of an exercise of public power incorrectly and unlawfully, like in this particular instance, is not moot. It was a very much a live legal issue as to whether the constitutional court judgment that incarcerated the former president was being given effect to. And the question then of the medical parole ties into that. And obviously, the decision of Fraser had to be legal, and that would never be a moot question. And then if we then speak to the question of the busybodies around whether AfriForum and the DA were actually had any standing to bring this case, Judge Mutojane very correct on the law, saying that the Promotion of Administrative Justice Act allows anybody to challenge an unlawful administrative action, which Fraser had taken in this particular instance. And more particularly, the Constitution allows justiciability of issues such as this. So it could never be a question that the DA and AfriForum were just simply busybodies that didn't actually have an interest. And then he tied that to the question of a public interest in this particular matter, and in particular, seeing that the rule of law is upheld. And on that basis, he found then that the DA and AfriForum had the ability to bring this matter and had standing to bring the matter.
On the aspect of public interest, the DA and the Helen Sundman Foundation contended that this case had repercussions beyond Zuma. When we think about it from a legal perspective, I mean, what are some of the repercussions that came to mind when this particular, I suppose, decision was made by the Correctional Services? Arthur Fraser.
The whole question of medical parole from 2012, and I like that the court dealt with the history of medical parole and how we got to this new dispensation. I think, the whole thing would have been rubbished. And that is a repercussion beyond Zuma. And you would have remembered that, Zuma raised the argument and Arthur Fraser raised the argument that there then should be a distinction. People that are incarcerated for less than 24 months would be entitled to a medical parole decision outside of the prescripts of the Medical Parole Advisory Board and doctor's notes and all of that kind of thing. And the court saying, well, that would actually be quite discriminatory, because what reason would there be for deciding on whether somebody is eligible to medical parole because he's terminally ill on the basis of how long they've been in prison or how long the sentence they're serving is. So again, had the court found that argument was substantive, that would have thrown this whole issue of medical parole into disarray, because there would be an unfair discrimination on prisoners based on how long they're in prison. The question wouldn't then be a question simply related to medical grounds, which is what this legislation seeks to give effect to. So those, I think, are the two sort of big areas where, had Mr. Zuma been successful, would have been impacted from a medical parole perspective.
Right. I suppose the other big aspect for me in reading this preamble was when Judge Mathojane laid out the detailed history of the events that led to Zuma getting parole. And he also gets to the point where he talks about that the Medical Parole Advisory Board did not sign off on the doctor's recommendation, as it didn't believe that it had enough information to make the decision. I mean, when you look at the timeline of events that led up to this particular decision, what stood out for you?
I think certainly, the sequence was a little bit suspicious, given when the former president entered into the correctional facility and his initial ingoing health assessment, and then the so-called deterioration of his health pretty rapidly after that, based on a condition which apparently he's had for a while, right? But I think even more interestingly is the fact that he had been stabilized. And when Arthur Fraser then makes this assessment, the medical grounds to make a medical parole decision are absolutely not there. And, by the time the Medical Parole Advisory Board had actually considered the matter, it had considered all relevant medical reports in deciding that he was not eligible for medical parole. So I think, Arthur Fraser really trying to tilt the factual background to suit Mr. Zuma, but very clearly, as the court saying, even the facts did not support that assessment.
Benedict, thank you so much for your time. That is Benedict Piri, the Managing Director at IUS Prudential Specialist Counsel. And in that preamble, wrapping it up by saying that the ruling makes crucial findings about the requirements that must be met for an inmate to be granted medical parole, and emphasizing the central role that the Medical Parole Advisory Board plays in such decisions. But for more, we're joined by SABC News senior political reporter Samkele Maseko. Samkele, thank you so much for your time this afternoon. I mean, from the people that you've spoken to so far since this ruling was made, what are some of the, I suppose, views and opinions that have come through following Judge Mathojane's ruling?
Essentially, what has transpired is that we've seen the spokesperson of the Economic Freedom Fighters, Rani Pambo, saying that what basis does it serve to further incarcerate former President Jacob Zuma, knowing very well that his incarceration caused mayhem and economic sabotage in the province of KwaZulu-Natal, while yet to hear the voices of the governing party, the African National Congress, what they have to say, particularly knowing that the North Gauteng High Court has ruled that the parole that was given by Arthur Fraser to former President Jacob Zuma is now null and void and set aside, and orders that the former president be sent back to a correctional services facility. The Jacob Zuma Foundation is yet to speak on these particular matters and ventilate what the former president thinks of this particular judgment, as with his legal team led by Advocate Dalimpofu. What we do know is that the Department of Correctional Services Facilities is saying that they are studying the judgment and they are pleading for time to come up with a comprehensive response to this. You'd remember that exclusive interview that our very own Vuyomboko of the Watchdog had with Arthur Fraser, where he said that he gave President Jacob Zuma medical parole going against the medical advisory board within the Department of Correctional Services, which advised against former President Jacob Zuma getting that medical parole. And we do know that parties like the Economic Freedom Fighters, through their commander-in-chief, their leader Julius Malema, have been very vocal when it comes to the incarceration of former President Jacob Zuma, saying that it was wrong and they don't wish for Jacob Zuma to spend much of his time in prison, as he is an elderly citizen. Then you've got the Democratic Alliance, who pretty much challenged this parole that was given to former President Jacob Zuma, led by their leader John Steenhuisen.
Right, Samkele, thank you so much for that. And